Ladies and gentlemen, boys and girls, hello, namaskar, and welcome to Law Charcha. Today we are going to discuss Bhartiya Nyay Sanhita, which came into force from 1st July 2024, and the Indian Penal Code 1860 now stands repealed. The society is based on certain rules and laws. There exist punishments for wrongful acts committed. These wrongs may be civil or criminal. For the purpose of punishing a wrongdoer for his offense, there is an established procedure. What actions amount to an offense is defined in Bhartiya Nyay Sanhita, that is the BNS in short form. It also contains punishments for every offense. Thus, BNS contains sections that define an offense, and it also contains penal sections that prescribe the punishment for the offenses that are defined. If translated to English, BNS means Indian Justice Code. Prior to BNS, that is Bhartiya Nyay Sanhita, the Indian Penal Code 1860 existed. One cannot ignore but notice that there is change in the name of the code. The term penal is changed to justice. Would the change in the name of the code manifest into better dispensing of justice? Well, only time will tell that. The BNSS brings some interesting changes, keeping in view legislative objective, which is to strengthen the law and order situation and also focus on simplifying the legal procedure so that ease of living is ensured to the common man. The intention further, as per the statements of objects and reasons, is to create legal structure which is more citizen centric and to ensure life and liberty of the citizens. If you notice in the Bhartiya BNSS, Bhartiya Nyay Suraksha Sanhita, Bhartiya Nagrik Suraksha Sanhita, the focus was there on Nagrik as well. So citizen centric focus is there in the objects and reasons of BNSS also and objects and reasons of BNS also. Pertinently, the statements of objects and reasons give reference to the 1834 Indian Law Commission that was constituted under the chairmanship of Lord Thomas Babington Macaulay to examine the jurisdiction, power, and rules of the existing courts as well as the police establishments and law in force in India during that time. The Indian Penal Code came into existence as the result of suggestions of the Indian Law Commission. This code continued with certain amendments that were fallout of the social changes. Most important amendment or amendments were with respect to offenses related to women, whether it is dowry or rape. Further, there were consequential amendments due to the enactment of the Information and Technology Act 2000. One of the objects of BNS is to streamline the provisions relating to offenses and penalties. While most of the definitions of offenses are same, there are some changes in the penalties. The substantial change in the is, if you notice, is the arrangement of these sections. As per the objective, the offenses against women and children, murder, and offenses against the state have been given precedence. Though it is not reflected how such precedence will be given, but the sections with respect to offenses against women and children or murder and offenses against state are incorporated in the beginning. But I don't know how by incorporating certain sections in the beginning of an enactment ensures that they are given precedence. This could be only a cosmetic change at the most in the code to show importance given to the offenses against women and children, or murder and offenses against the state. Be as it may, the enforcement of those sections will obviously not change depending upon the order in which they are reflected in the enactment. Therefore, this in fact is change in the structuring of the sections and the act. The structural change is apparent from very first section, where multiple sections that were part of the preamble chapter in the IPC are clubbed under single section. Likewise, the chapter on general explanations is converted into a single section. The section 2 is given heading as definitions, which replaces the entire chapter of general explanations. Most of the definitions are reproduced from the general explanations chapter as it existed in the IPC. A definition of child is added in section 2, subsection 3. Furthermore, in the definition of gender, the word transgender is also included. This appears to be a result of the recent progressive judgments by the Supreme Court, emphasizing on the gender inclusive society. The section 3 is given heading as general explanations, which was the heading of an entire chapter in IPC, under which definitions were also provided. Section 34 of the IPC, which is with respect to common intention, is added as subsection 5 of section 3. Section 8 also clubs many sections into single section. The sections with respect to fine, imprisonment, defaults in fine, etc. are clubbed together and incorporated under section 8. In section 4, which deals with punishments, a new category is added. The legislature for the first time intends to incorporate community service as punishment for petty offenses. Community service as a punishment is provided in section 202, public servant unlawfully engaging in trade. Section 209, non-appearance in response to proclamation. Then section 226, attempt to suicide, to compel or restrain exercise of lawful power. Section 303, proviso, which is with respect to theft, where value of stolen property is less than 5,000 rupees. Then section 355, misconduct in public by a drunken person. Section 356, defamation. So these are some sections where community service is prescribed as the punishment. Though the punishment of community service is provided, there is no guideline with respect to the nature of the community service. What is going to be that community service? That is left to the court, I suppose. Apart from the addition of community services, there are certain changes in the penal sections. The quantum of sentences have been changed for certain offenses. For instance, punishment for rioting under the old act, that is the IPC, was up to 3 years under section 148. Now under the BNS, under section 191 subsection 3, the punishment is enhanced to extend up to 5 years. Though it is pertinent to note here that there is no minimum sentence provided. Therefore, even under the new section, the punishment for rioting is 5 years, that is the maximum. There is no prescribed minimum limit. So the accused can be sentenced for 3 years also. But the intent behind enhancing the upper limit of sentence appears to be for enabling the court to exercise its power suitably and more flexibly considering the gravity of offense committed. In other words, the power of the court is not curtailed by limits in sentencing. Enhancement in sentences would give more teeth for delivering better justice. Another example of enhancement in sentence is section 139 of the BNS that deals with kidnapping or maiming a child for purpose of begging. In the earlier section 363A for kidnapping a minor to use him for purpose of begging, the sentence was imprisonment of for a period of uh, the period extending rather up to 10 years. This is changed to imprisonment of life. Further, under the same section, imprisonment for maiming was for life under BNS. The same is specified as imprisonment for remainder of that person's natural life. Thus, the legislature has shut the chances of early release of the prisoner. Such expression of punishment by using the phrase remainder of that person's life can be traced in section 376 of the IPC. The legislature has found it suitable to use the same expression in the new sections of other sections of BNS also. In many sections of IPC, there was no fine amount prescribed. The courts were empowered to levy fine, but there was no specific amount provided in those sections. For instance, under section 152 of IPC, which dealt with assaults on public servant, when suppressing riots, there is provision of fine for offense committed, but no amount is prescribed. Under BNS, in the corresponding section, a minimum amount of 25,000 rupees is prescribed. Incorporating a minimum amount of fine is a noteworthy change, I must say. It can be only hoped that such changes can put some deterrence on the wrongdoers. But the changes appear to have been done selectively. There is no reason provided behind such changes. For instance, similar change would have been made to section 153A of IPC, which deals with promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to the harmony, maintenance of harmony. There is no change to this section, although the offense is, if not more, equally grave. So, serious in comparison to the one under section 195, which I mentioned earlier. But the corresponding section to 153A of IPC is section 196 of BNS. Both sections are verbatim. The changes in punishments are not consistent. So I feel that there should have been changes in punishment in these sections also. And there is no statement, there is no reason given in the statement of objects and reasons of these sections. Now, the statement of objects and reasons state that the fines and punishments, they should have used the term sentences because fine is included in punishment. So they have used fines and punishments. They should have used the word sentences. For various offenses have been suitably enhanced. So one cannot ignore but notice that unlike changes with respect to fines and sentences incorporated in sections 195 and 196, there is no change in section 171E, which relates to bribery and falls under chapter of offenses relating to elections under IPC. The new section 173 on bribery is verbatim of section 171E of the IPC. Furthermore, although fine in the punishment for wearing garb or carrying token used by public servant with fraudulent intent under 171 of IPC is enhanced to 5,000 rupees in the corresponding section 205 of the BNS, no enhancement is done to the fine amount in section 172 of the BNS, which deals with personation at elections. So these changes are done very selectively, it appears. There is no benchmark or no foundation to the changes of enhancement of punishment or enhancement of sentences. Another noticeable change in the fine is under section 172 of the IPC. It deals with the punishment of absconding to avoid service of summons. Earlier, 6 months imprisonment or a fine extendable to 1,000 rupees was the punishment. Now, in the new section 206 of the BNS, the fine component is enhanced as extendable to 10,000 rupees. This is a positive step towards ensuring appearance of the accused. The non-appearance of the accused had been major cause of delay in trials in the courts. Hence, with enhancement of punishment, one can hope that the accused would appear before the courts and respect the summons order of the courts. In most of the changes of enhancement in fines under BNS, the fine amount has been increased to either 5,000 rupees or 10,000 rupees. Under IPC, the fine was usually in between 100 rupees to 1,000 rupees. The changes in punishments are an impactful factor contained in the BNS. Section 48 of the BNS is crucial because it recognizes abatement done outside India. This is a new provision. There was no corresponding provision in the IPC. Under IPC, only abatement of offense done in India was provided for. In BNS, under section 47, abatement in India of offense outside India is provided, and under section 48, abatement outside India for offense in India is provided. The BNS brings some rational changes to sections. For instance, section 232 of the IPC dealt with counterfeiting Indian coin. In the corresponding section 178 of the BNS, in addition to coin, the legislature has added government stamps, currency notes, or bank notes. This change might be in keeping with in mind the change in nature of transactions over a period of time, over a period of century rather, and use of medium of exchange for such transaction. Similar consequential changes are incorporated through sections 179, 180, 181, and 182 of the BNS. The entire chapter on offences relating to weights and measures is dropped from the BNS. This is because a separate legislation dealing with the offences relating to weights and measures is already in force. That is the Legal Metrology Act 2009. The sections 310 and 311 of the IPC find no place in BNS. The said provisions defined a thug and provided for its punishment. Thug was a term usually referred to assassin and robbers from India by the British. Therefore, this provision was relevant only under the British rule. Hence, it has no relevance today, and rightly it is done away with in the BNS. Under the section 330 of IPC dealing with voluntary causing hurt, there was an illustration with respect to zamindar and tortures committed by them. Since post-independence, the zamindari system itself is abolished, the illustration is removed, and hence it does not find place under the corresponding section 120 of the BNS. As mentioned earlier, the BNS has defined certain terms like child. The definition becomes relevant in sections like in 295 of BNS, which is with respect to offences of sale, etc., of obscene objects to child. Earlier, this section was worded under section 293 of the IPC as sale, etc. Of obscene objects to young persons. The earlier section did not define the term young persons used in the heading, and the section did not contain the term young persons in its text. Instead, it used the expression any person under the age of 20 years. Pertinently, the new section under the BNS uses the term child, which would mean person under 18 years of age, as against the 20 years used in the previous enactment. There are some new sections added in the BNS that supposedly introduces new variant of offenses in the code. Section 103(2) deals with situation when a group of 5 or more persons acting in concert commit murders on grounds of race, caste, or community, sex, place of birth, language, personal belief, or any other similar ground. Though words mob lynching is not used in the BNS, the intent that one could decipher from the section suggests that this provision is to incorporate the offense of mob lynching in the BNS. If we observe IPC and even the BNS comprehensively, the provision under section 103(2) of the BNS looks repetitive. The provision appears to be combination of section 34 of the old act, that is IPC, which dealt with common intention, section 120B of the IPC, which dealt with conspiracy, section 141 to 145, that is offenses related to unlawful assembly and its variants under the old IPC, section 302 of murder under the IPC. All these IPC sections are reproduced in the BNS as section 3 subclause 5 subsection 5, section 61 subsection 2, that is conspiracy, section 189, that is offense of unlawful assembly and its variants, section 103 subsection 1, murder of the BNS. Now, committing murder itself is an offense, irrespective of any ground, whether it be on basis of race, caste, religion, etc., etc. Furthermore, the punishment for murder is also life. Therefore, it is not the case that if grounds of murder are different, then the punishment would be different. Similar anomaly can be traced in section 117 subsection 4, which deals with voluntary causing grievous hurt. The section 106 of BNS deals with offense of causing death by negligence. A lesser punishment is carved out for medical practitioners, while the punishment for causing death by negligence is extendable to 5 years. If such death occurs while performing a medical procedure, the punishment is extendable only to 2 years. Section 95 of the BNS is a new section which has no corresponding provision in IPC. It deals with hiring, employing, or engaging a child to commit an offense. There is an explanation to this section which specifically deals with sexual exploitation of child. If one reads sections under chapter 3 of the Protection of Children from Sexual Offences Act, that is the POCSO, it will be apparent that legislation brought in the explanation to section 95 of BNS already existed in chapter 3 of POCSO. There is no section in BNS corresponding to section 377 of IPC which dealt with offense of unnatural sex. This is because post judgment by the Supreme Court in the case of Navtej Singh Johar versus Union of India, the provisions under section 377 of IPC was declared unconstitutional. Similarly, there is no section in BNS corresponding to section 497 of the IPC which dealt with adultery. the Supreme Court had struck down Section 497 in the landmark judgment of Joseph Shine versus Union of India, thereby decriminalizing adultery. Well, from what we can gather from the various provisions which are again adopted from the old IPC and some changes brought in the BNS, it is a new manual that expound the actions that are regarded as offenses in India. The BNS bestows new penal provision with reformed fines and sentences as punishments. So let's hope that this new BNS brings some positive changes in the legal system. So with this, we are done with the discussion of BNS. Thank you. Namaskar.